Representative Johnson?
And just to clarify, the physical condition aggravated by, caused by, or arising from a pregnancy that places the female at risk of death. Risk of death is life-threatening, right?
Yes, ma'am. Risk of death is life-threatening.
Okay, so removing that phrase life-threatening before risk of death, you still have risk of death.
No, ma'am.
You do.
No, ma'am. It's not true.
It says places the female at risk of death.
Under one of the two options whereby an abortion is permissible, that is true. But there is another option for which risk of death is not a requirement.
Okay, and so you're right, there's a second prong. If she's about to die, you can perform the abortion. But the law, and this actually goes back to SB 8, right? Which is serious risk of substantial impairment of a major bodily function. That's SB 8. That's a heartbeat bill.
That may be. I'm not going to comment on that.
It is.
I will stipulate that that is the case for purposes of our
Yeah, so
conversation.
that is actually that provision, the change here is the fact that you don't have to wait for the impairment. And that's consistent with the all-Republican Texas Supreme Court in Zawoski saying that we don't need to make women suffer serious bodily injury. We want to prevent it. And you would agree that a woman's fertility is valuable, right? Just like a man's?
I don't think it, well, let me say it this way. The law that the Texas Supreme Court interpreted did not require any kind of imminent risk of death on the part of the woman. It is not current Texas law that you have to wait until the woman is almost dying in order to intervene if you think an abortion is necessary to save her life. And that's what the Associate General Counsel of Parkland testified to. He said, the law is clear. Me and my doctors and my lawyers, we know what to do. It's the rural doctors who are confused by the law, right? So the current law says there is no temporal requirement. You don't have to wait till a woman is about to die in order to intervene by aborting a baby if her life is at risk, and no change to the law needs to happen. My issue with this bill is that it actually changes the law. It's not simply providing clarification or education, it's changing the standard. And the current standard under Texas law, according to Zarowski, is a woman has to be in threat of death before abortion is even on the table.
Right. That's what you just said. You just said that a woman has to be at threat of death.
It doesn't have to be imminent. You use the word imminent, and I'm making a clarification.
But you're saying threat of death. And that's why we're trying not to parse those two, because the second part of that standard is risk to a major bodily function.
If you remove life-threatening from this bill, then simple threat to a major bodily function becomes enough to consider an abortion. Yes, ma'am.
And physical, not mental. So you said, I just want to clarify, because trust me, this is not all I want in this bill. This does not deal with rape, incest, doesn't deal with fetal abnormality or many other things that we could debate. This is purely a medical exception and a cleanup. But I want to be clear, this does not give mental health. This requires a physical condition.
Unfortunately, those who are pro-abortion have frequently used mental health as an example of
Physical condition, page 2, line 5. Right where you complain about the strike of life-threatening, it literally says physical condition. So
Yes,
I appreciate your testimony. I don't want to provide the wrong testimony, and that's why I wanted to help you clarify. I understand what you're saying, but you understand the bill requires a physical condition.
I understand the bill uses the word physical, and I also understand that those who are engaged in this fight, who are attempting to increase access to abortion, frequently cite to conditions or symptoms of mental health that are physical to argue that physical requirements do not limit or prevent a doctor who wants to give an abortion from giving it.
Of a major bodily function. And that's a consistent medical analysis that it would be really hard to start picking and choosing which bodily functions are more significant than others, right? Heart, lung, kidney. We want the physicians to make that decision, right?
I think physicians are ready to say that, for example, in the case of mental health, your neurological system is a major bodily function, right? So somebody with mental health has a neurological condition that affects a bodily function, and therefore, if the only requirement is a physical condition that threatens a major bodily function, mental health is sufficient to justify abortion under a new standard.
And in the same way, if mom is in distress and we have an oxygen issue or anything else, and you're going to lose brain function, you would want to do what you can to protect the brain, right?
Absolutely, yes.
And so you are, again, trusting physicians in each and every case to make the decision that this bill requires shows a physical condition of which leads to a risk of an impairment, serious risk of substantial impairment of a major bodily function, correct? And then one more thing, because you said on Cox, and Cox talks about good faith. The Supreme Court made it very clear. Physicians can't predict in good faith. We are requiring a physical manifestation and direct evidence of a physical manifestation in 44.
That is the word that the statute uses, ma'am. I'm not disagreeing with that at all. What I'm saying is that in the way this gets played out on the ground, physical condition is not a limitation for those who want to use things that you and I sitting right here might not agree are physical conditions.
So let's talk about the play out on the ground, because this is another area of debate.
Yes, ma'am.
I have not met an OB-GYN that doesn't do everything in their power to deliver a healthy baby. And as a state, we've already decided that we don't trust women to make that decision about their babies. But right now, we're not trusting medical professionals to do that either. We are not talking about elective abortion. We are not talking about choice. We are not talking about abortion providers. We are talking about physicians in our emergency rooms that see women bleeding who can't perform regular medical modern technologies because they are afraid that folks politically think they're trying to do something wrong. They're just trying to perform health care. And all this bill does is say that when you see that physical manifestation of an indication that a major bodily function is at risk, you don't need to make her get at death's door before you practice your job. Because not doing that is making these people leave the state of Texas. And it is hurting us all. So I do understand your position. I appreciate the recognition that I'm on the bill. This is not partisan. This is health care, and this is about saving women's life free from an abortion debate. Because you've already won that. Thank you for testifying.